Morning, everyone. It's just 11 o'clock. I've started the webinar, so now people can join and I can see people are joining, which is great. We've got nearly 200 people signed up for today's webinar, which is fantastic. So just going to allow as many people as possible to join us live before I start. Well, good morning, everyone, and welcome to our July webinar. This is the last webinar that we'll do before we take a short break in August before we return in September. So today, I am going to be talking about contracts of employment, and more specifically, how we can use our contracts as a business tool. How can we make them more effective? How can we make them more strategic? And I think sometimes we pull out a contract maybe from the previous one we did before, and we just, cut and paste the name without really thinking what the contract is and just how powerful and valuable it is to your business. For those who don't know me, I'm Emma O'Connor. I'm a lawyer in our employment team, and I also head up our HR training academy. For those of you who don't know Boyce Turner, we're a commercial law firm in the Thames Valley, although we act for clients across the UK, Europe, and also globally. And within our employment team, we help clients with day-to-day HR support. We help with restructures, we help with litigation, training as well, and we also help with business immigration. So if there's any help or assistance we can give, then do get in touch, and my contact details will be at the end of this webinar. Also, a bit of housekeeping. We are live today, so again, please post any questions that you have, and I will try and answer those at the end. If they're too business specific, then I'll come back to you separately, and also depending on how the time allows. Appreciate we've all got busy days and busy diaries. Also, this is an overview, so I'll just be giving you some general tips, my top tips as to how we can use our contracts more effectively. So again, if anyone has any specific questions or requires any specific help, then please do get in touch. And certainly this webinar is no substitute for taking your own specific legal advice. So what am I going to be talking about for the next sort of 45 minutes or so? Well, firstly, I want to sort of take a little bit of a step back and talk about what the contract of employment is. Then I want to have a talk about, how that contract is formed and what are the special elements with regards to forming a contract of employment. Then I really want to sort of take you through some of the key areas where I see we could be using our contracts more effectively. And that's really around kind of those termination provisions. And also those provisions when we think about protecting our confidential information. Remember, your information is incredibly important, incredibly valuable. So how can we make sure that that information is protected, both during and obviously after employment, intellectual property, and then I will talk as well about restrictive covenants and those other business protection terms that we can include. So let's get started. So the employment contract is really no different to any other commercial contract. It's an agreement between two people. And the elements of a contract of employment, as for any contract, would be that there is an offer, there is an acceptance, there is what we call that intention to create legal relations. So the parties want to join together, they want to be employer and employee. And there's also consideration, so that price that's being paid for a promise. And at the start of employment, when we offer a job and that's accepted, that consideration is the fact that they have a job and that they will be paid for their work under that contract of employment. Now, a contract of employment, as I've put there, is a contract of service. It's not a contract for services, which would be where you have that self-employed relationship. The employment relationship, as we know, has that mutuality of obligation amongst other key factors, but that mutuality of obligation where you have the employer giving work and the employee having to accept that work in return for a wage. It's not that self-employed relationship where the self-employed individual can choose who they work for, where they work, how they work, and if they actually do the work themselves or send a substitute. In an employment relationship, we don't have that. The employee must perform the services themselves personally. And whether we know it or not, all employees will have a contract of employment. And the contract of employment can actually be formed in lots of different ways. And yes, we have our nice, sort of document that the employee signs, but contractual terms can be formed, they could be included within the offer letter. So always check that offer letter before it goes out. Have we really got all the details absolutely spot on in that offer letter, particularly around salary and obviously job title, etc. So again, really focus on that offer letter. Then we would have our terms and conditions of employment or standard contract. And in that we would have our express terms. But also contractual terms could be formed in a collective agreement if you have trade union recognition within your place of work. We also have terms that are statutory, so those statutory minimum terms that employers can't go below. So, for example, things regarding working time or holidays, health and safety obligations, they are all part of the employment relationship, whether they're written in the contract. And then we have those implied terms, don't we? Those implied terms, for example, of trust and confidence, and also with regards to sort of, certain health and safety obligations as well. And also we might have contractual terms that are formed over time. So things that are not written down, but the way that something has always been done. So for example, it might be something that you have, for example, you always pay a Christmas bonus, you've always paid a certain amount afterwards. And I just want to say a quick word about policies, because often I think we get a little bit confused as to how the whole kind of handbook or the whole policy thing fits with our contract of employment. Now, yes, we should refer to the fact that we have certain policies within our contract of employment. So certainly we should be referring to the fact that we have disciplinary policies, we have grievance policy, equal ops. We may also want to refer to things like social media and data protection policies, health and safety as well. But those policies are non-contractual. So those policies should always sit outside of the contract, and that's really important. So in our handbook, for example, or in a start of our policies, we will always have something, and certainly the ones that we draft, that will say that obviously this policy must be followed, but it does not form part of the contract of employment, and it may be amended by the organisation. So there is this clear distinction between, this is the contract, these are our express terms, this is how our relationship is going to work, but then sort of underpinning that in terms of our culture and the way that we want to work with you, promoting those good behaviours, those wanted behaviours, then we would have our policies that would sit outside of that contractual relationship. And it's always worth, keeping those policies up to date. Not only does the law change, but also, the way that we want to work together, our culture and it's an engagement document. So again, it's worth having a look at that as well. I would say particularly with regards to anything procedural, so anything to do with discipline, grievance, performance management, those policies should always sit outside of the contract of employment to allow you that flexibility to be able to use your policies as fits the purpose, as fits the situation that you find ourselves in. It's not a mechanical process, but it's one that has to sort of develop and evolve depending on what the situation is that you're being faced with. So again, please do check those core policies and always make sure that they are non-contractual. So why do we give employees a written statement or a contract of employment? Well, the easy answer is because the law tells us that we have to. So there we have Section 1 of the Employment Rights Act, which has changed, and it changed a couple of years ago to basically require employers to provide employees and workers with a core set of really kind of, basic terms on or before they start work. So it used to be that you had that sort of 2-month grace period in which to give people a written statement of terms. That has now changed, and it has to be on or before. Now, Section 1, as I've said, it's that written statement of employment particulars. So some employers do just have those sort of, really basic particulars, whereas others will kind of add in those business protection clauses, particularly for our more senior employees that I'm going to come on to talk about. But that Section 1 information is really the kind of the basic stuff. So who is the employer? Who is the employee? A bit about what the employee is going to do, obviously what they're going to be paid, how they're going to be paid, information there around hours of work, days of work, of course, we must include that. Some basic information around notice periods as well, that needs to be included in there. Information around holidays, any entitlements to other benefits and other leave. So if you have enhanced statutory leave, maternity, etc., that's applicable. We also have to put in there about the place of work as well, and where will the employee be working, and also information if the employee is going to be working outside of the UK for more than a month, and how that affects things like their pay. So are they going to be paid in a different currency, and also what happens when the employee returns to the UK. So Section 1 is really, as I've said, that sort of basic set, that sort of core nuts and bolts of the employment relationship. But for many businesses, that isn't enough. We need to include more information, and certainly the direction of travel when it comes to contracts of employment is very much that there is that sort of idea of including more protection, including sort of, longer notice periods, of including more information, particularly around place of work, where we want that flexibility. Maybe we want to look at having, a core place of work, and then maybe we want to allow sort of a bit of, hybrid working as well. So it's really worth kind of thinking about how you want to structure your contracts of employment, and whether you actually need to include more than what the Section 1 statement is. So if we think of our Section 1 statement as more of that kind of baseline, what I want to do now is talk about some of those challenges that perhaps we have, thinking about how we can make those contracts more effective. So let's have a think about those clauses. So one of the key clauses that we will want to think about, and certainly something that's within our sort of, HR toolbox, our HR armory, is when we think about termination. And I know that sounds really strange, doesn't it? Because we're very excited that someone is joining us. We want to have that really positive relationship with them, with our new joiner. But actually, it's really important that when we do put the contract together, that actually we think about how we're going to bring an employment relationship to an end. So for a lot of our corporate clients, when we work with them in terms of setting up their business, actually one of the things that we will talk about first with them is, what's your exit plan? What's your exit strategy? And as I've said, the employment contract is really just a special contract, a special commercial type of commercial contract. So think about how you want to perhaps bring that relationship to an end, and think about that at the start, rather than obviously when we do want to get to if we do get to the end of the relationship and we find that our hands are tied because we haven't thought about it at the beginning of the relationship. Now, we do have statutory minimum notice periods, and they're effectively, 1 week for every completed year of service up to a maximum of 12 weeks. And often in the contracts that I draw up, I will find that clients will want that sort of shorter notice period, particularly during a probation period. So you might find that during periods of probation, you have a week. Some clients might want to say, well, we want to have 1 week during that, during that sort of first year of employment as well. So really think about what type of notice that you need. Also think about perhaps having a hybrid. So for example, you might have a situation where you have a month's notice, and then when you click over to sort of 5 years service, you then sort of, switch back into the statutory notice period. So again, you can kind of flex your notice period depending on role, depending on need. But what I will say is whatever you decide, notice must be reasonable. So again, that statutory notice, that's the minimum, that's your baseline. You are able to increase that notice, but it's got to be reasonable. I would also have in there the ability for the employer to require the employee to take their holidays during notice as well. That's quite a useful tool to have, but obviously remembering that if there isn't enough time for the employee to use up their holiday, then again, they will be entitled to be paid for any holiday that's accrued upon termination. But also we need to think about, is that statutory minimum notice, or whether we want some sort of, kind of hybrid of the 4 weeks and then the statutory, is that going to be enough? Do we perhaps need a longer notice period? So I'm thinking here of maybe a 3 months notice period, or perhaps a 6 month notice period. And why might we want a longer notice period? Well, we might want a longer notice period because actually the individual involved is very senior, and it's going to take us a period of time with which to find their replacement and get them, signed up, etc. And we don't want to be left with a period of time where we don't have somebody in place. We can also use that longer notice period perhaps to prevent the individual from leaving and joining a competitor. And I'll talk about other tools that we can perhaps use in that scenario as well. You may need to have that longer notice period to allow for there to be an effective handover with an individual. And you may need to allow for more sort of, departmental planning. And certainly now, as we've seen, when it is becoming harder to recruit certain roles and find individuals with those sort of, key skills that we're looking for, perhaps we do want to have a longer notice period, again, to make sure that we've got the time sort of built in to be able to ensure that we can find the right person for the job to take over, whether that's an internal position recruitment process or an external one, or both. So again, do think about why you might need a longer notice period. And also think about, maybe things change as well. It might be that actually as somebody moves forward with their career and they get promoted into a new role, that maybe you need to go back and revisit the notice period and other clauses within the employment contract. So, the employment contract is not, once signed, it stays the same forever. I think we need to think about our contract as this sort of living, growing organism that develops and changes as perhaps your business grows, the law changes, or the individual changes their role as well. So it shouldn't be seen as as kind of a fixed document, fixed at a point of time. So think about, are we revisiting our contracts when we have pay review periods, or whether we have when we're promoting individuals as well. So I've spoken about whether we have that longer notice period, particularly for perhaps more senior roles, for roles where we are thinking, perhaps it is more difficult to recruit for. But also you can use your longer notice periods as a sign of investment in an individual as well. A longer notice period could perhaps be seen as something that just is sort of signaling to the individual that, look, we value you within the organisation. And as a sign that we value you, we are actually going to give you a longer notice period. Now, longer notice periods can be, a useful tool, But we also know as well, don't we, that, you know, locking somebody within the business for, 6 months, 3 months or 6 months might actually not be what we want to do. So how can we use our contracts more effectively to give somebody the comfort of a longer notice period, to give the business the comfort of a longer notice period? But how can we flex that? Just another word about notice periods. Notice periods don't have to be the same. So it might be that the employer, yes, you have to follow the statutory minimum notice, but you may find that you have a different notice period to the employee. So perhaps the employee is required to give you less notice than you're required to give. I tend to find in practice that notice tends to be reciprocal. So if you've got, for a month and statutory thereafter, then we ask the employee to also give us the same notice. But again, you may want to have different notice periods. I would also include in there the mechanics of giving notice. I think that's really important because, we need clarity in this. So we want notice to be in writing. And I think that's, something that we should be including within our contract. So the employee must give you notice in writing as well as you giving notice in writing. So what other tools can we use, when we think about termination, when we think about bringing that employment relationship to an end? Well, another clause that you might want to add, a couple of clauses, you may want to add what we call a pile-on clause, a payment in lieu of notice clause, which effectively says that we will bring your employment to an end on a certain date, and rather than you working your notice period, we're actually going to pay you your equivalent notice period rather than you work it. I always like to say in those situations that I like to include in those situations that we must be paying notice in terms of that basic salary only, please. So again, make sure you've got basic pay defined within your contract of employment. Often I see contracts that use basic salary, full pay. What does that mean? So again, make sure you've got that clarity. This is your basic salary. This is what we're going to use to calculate things like, bonus, but also, your notice pay as well. So that's really important to have that clarity. Pile-on clauses are again very useful because, as I've said, they bring employment to an end at a certain date. So you can calculate obviously all your holiday and your benefits up to a certain point, and then we pay notice thereafter. It's really important when we think about the pile-on clause that we have the flexibility within that clause. So it's not an absolute right, but it is one that says, the employer may choose to end employment and pay you in lieu of notice. Again, you're reserving that right, that it's not seen as something you do in every single case. And you may also want to include the flexibility within there, particularly if you've got someone on that longer notice period to pay notice in installments. There are ways in which you can do that as well. If you are going to use that pile-on clause, again, you need to confirm in writing at the point that you're going to use it, that you are going to pay in lieu of notice. If you do pay in lieu, obviously the employee has a fixed termination date. So effectively they are free after that point to go and, find another job with a competitor, again, subject to anything that may or may not be included within their contract. But you do have that certainty. And, some employers do prefer that, particularly if you've got somebody who is being disruptive or somebody that you want to end employment now. You've got that ability to do that with a payment in lieu of notice clause. Another clause which I would definitely recommend you having is a garden leave clause. It's incredibly useful and incredibly powerful clause actually within your contracts of employment. It's been quite a lovely week, hasn't it, to be on garden leave? But essentially what garden leave gives you, the employer, is that ability to say, right, we understand you've got this notice period within your contract. We don't require you to work during that notice period, or We might want to put you onto special projects, or we might want to kind of, sort of change what you do. But effectively, we don't want you to do your job, but we still want you to be employed by us. So what we're going to do is we're going to ask you to refrain from coming into the office, refrain from contacting clients or customers or your colleagues. And effectively, we will just continue to pay you your salary, your benefits, your holiday, during what effectively is your notice period. So yes, you still have to pay during that period, and yes, the individual would still be entitled to all their benefits during that notice period. But it is incredibly important, and it's a very powerful tool, because when somebody is on garden leave, they are still your employee. So they're still bound by their contract of employment, all of those terms with regards to their duties, all of those fiduciary duties that they owe their employer, to act in your best interest, to not work for a competitor, to not divert business interests. So, they are our employee, even though they are not actually physically doing any work for us. And that can be a really powerful tool, particularly when we come on to think about maybe having some form of restrictive covenants on behavior post-employment. So I definitely would, particularly for those individuals who you've got that long notice period for, I would definitely have within that the option to be able to place somebody on garden leave. And also within that garden leave clause, again, give yourself that flexibility. You may want to put somebody, as I've said, on a special project. You may need to call somebody into the office, particularly if you need to do some handover work. You may need to call somebody in the office to obviously do that sort of, property, giving back laptops, phones and things like that. So again, that's a really, those are sort of really important things to include within that garden leave provision as well. I'd also include clauses in there that allow you to bring employment to an end immediately when you have summary dismissal. So you have gross misconduct or gross negligence as well. So again, that's another useful clause to have. So again, it's that we have our disciplinary code that sits outside of our contract, but just to be very, very clear, we reserve that right within the contract to bring employment to an end if you are found under that non-contractual code. So that's a really important clause to have in there. So yes, pylon is really useful, particularly where you want to bring employment to an end immediately. But I do think having that garden leave provision, having that ability to effectively keep somebody away from joining a competitor, keep somebody away from taking those preparatory steps, keep them on the books, and keep them employed, keep them under their terms and conditions of employment, because, once they do leave, yes, there are things that you can do, but it's almost like they've gone. What can you do now? And what you do want to do is going to cost you some money and take some time. So use that period, use that garden leave period as that chance to be able to, shore up those client relationships, get your plans in place for recruitment, make sure that you're prepared in terms of, this individual is leaving, how can we make sort of, departmental changes? So how can we make that leadership structure work? So very, very useful tool there. Other clauses that I would like to see in an employment contract are ones that think about our data, our information, what we have, our client lists, our employee lists, information about software, information about databases. It's all really, really valuable stuff. And obviously, while somebody is in employment, they're your employee and owe you certain duties. But once somebody leaves employment, then really it's only those trade secrets that is, protected. So if we want to increase that protection, enhance our protection, then we need to have that express clause in there that says, during and after employment, you won't use our data in a way that we have not authorized you to do so. Effectively, that's what we're saying. What's important is to make sure that we have clearly defined what confidential information is. And so I would always kind of set out clearly, you know, what we say the confidential information might be, because it may be that there's something very specific to the individual's role or to your organization that needs to be protected. So think very clearly when you are putting together those confidentiality clauses, and push back to the business, you know, what is your confidential information? Because, you know, we can only include within our protective clauses what we know about. Now, it may be that you have a separate confidentiality agreement with your employees as well, and that's fine as well. Obviously, making sure you've got that during employment, but also after employment as well. That's fine to do. But I think, you know, often we have those sort of template clauses that have just, you know, been in there since the year dot, and we haven't really thought about how perhaps technology has moved on and how we need to incorporate that within our contracts of employment. And another quite interesting development that we've seen over recent years has been who owns a LinkedIn account, particularly where you've got individuals that manage your business's LinkedIn account. Perhaps they manage your business's Facebook or Instagram or other social media platforms, Twitter, for example. So what happens with all of those, that contact and that content? So we've seen cases where employees have left, they've obviously taken the sort of a LinkedIn contacts with them. Well, who owns that? And it's going to be very much in terms of, you know, what's the employee's role, who have they, and how have they got the contacts? So again, LinkedIn is another interesting development where perhaps, you know, as I've said, we've got those sort of very generic information clauses, the confidential information clauses, and we haven't really thought about the world in which our business now operates, particularly where you've got, you know, marketing and business development roles. So again, think about how we want to use our business protection clauses in a more effective way, thinking about how our business operates now and not perhaps how it operated, you know, 10 to 15 years ago. So another clause, again, sort of linked to confidentiality, is obviously intellectual property as well, you know, where you've got individuals who have those creative roles, even, you know, a PowerPoint deck, you know, that's creative. You're creating content, you're creating, you know, copyright material. So again, we need to be very clear with regards to the ownership of anything that's created during employment. And make clear that we've obviously got that ability within the contract to ensure that where employees are creating that IP, that intellectual property, that we've got the ability there to be able to get the ownership of that IP. And particularly where you've got those individuals who are in perhaps a, you know, a research and development role. Again, you know, making sure that we've got that ability to be able to do that. And also we need to think there about, you know, moral rights. So not only is that kind of ownership, but also there is kind of moral rights that individuals have in works that they have created. So whilst, you know, they may transfer the ownership of that, they still have some, you know, moral right in what has been created, even if they don't own it. So we need to think about how we can ensure that we're protecting and those moral rights, as well as ensuring we've got that ownership there for the business as well. There's always a bit of a kind of a, you know, bit of a grey area where we have employees who are creative outside of the office, outside of work. So maybe they like to, you know, tinker with things in a shed, or perhaps they've got their own kind of separate business and things like that. So again, it's very important that you know that it's what's sort of linked to their employment and what's created during the course of employment. So again, it may not be everything that that the employee does outside of work that you can have an interest in. So again, just sort of having those clear parameters. So I do spend a lot of my time reviewing contracts and drafting contracts and advising businesses on their contracts. And certainly I've seen over the years a shift. I've found that contracts now are drafted in plainer language. I've found as well that the contracts that I'm drafting are longer, certainly. And I know that, can be slightly off-putting, but I do find now with the amount of information and the amount of ifs and buts and what ifs, that, the contracts that we're looking at and the contracts that we're drafting are longer. And one area where I find that businesses are still keen to have clauses on are business protection. So those post-termination restrictive covenants. Now, restrictive covenants they can be great and they can be a very useful deterrent, but they're not an easy clause to either draft or to try and enforce. What you're essentially doing with a post-termination restriction or restrictive covenant, however you want to whatever you want to call them, you're effectively trying to stop somebody doing something once they've left you. So we've had our employment relationship. That's great. Let's just go our separate ways. But we're going to try and put some limits and parameters on what you can do in the big wide world. So restrictive covenants, they have to be reasonable. There has to be that balance between protecting your legitimate business interests and against the employee's ability to work, to go out there, get another job, set up their own business. So there is this balancing act that has to be done. Now, they can't be used as a restraint of trade. There must be something about what the employee does for you, what they know about you, and what access they have to your clients or your confidential information that makes them a particular risk when they leave you. So it's not, you can't work for anyone, anywhere, doing anything ever again. There has to be some limits in terms of what it is the individual can do, and it must be in competition with you. There has to be that element of competition in what it is they are proposing to do. So they must be reasonable in terms of their geographical location. So, if the employee is only based in a certain geographical location, or only looking after clients perhaps in the UK, or you couldn't then say, well, you can't work for anybody worldwide. And actually sometimes you see restrictive covenants drafted incredibly narrowly. I've drafted covenants for hairdressing salons where their client base is so incredibly narrow. You might find that you have just in one town or one sort of very limited part of a town. So for example, not allowing a hairdresser to work in London would probably be unreasonable, but you might have that you can't be a hairdresser in a particular square location, square mile may be reasonable. So they must be reasonable in terms of their geographic scope. They must also be reasonable in terms of time. And really what you're thinking about is, how long do I need to protect my business? So how long do I need to be able to, shore up those client relationships, keep the team happy, get someone in place, to kind of keep the ship sailing? Again, and it might be as well that you think about how reasonable it might be in terms of how long confidential information is confidential. It might be that it's just, we're looking at maybe a monthly cycle or a 6-monthly cycle. Certainly the longer that you try and stop somebody from working or doing their job, it's got to be reasonable. It has to be legitimate. You can't just stop somebody from doing something. There has to be something about what that individual does or knows against what it is we are trying to stop them or limit them from doing. So really, again, think about what it might be. And also different employees need different protections. And I think that's really important. And I think we really have to avoid having those blanket terms within contracts of employment. We really have to think about, what does this person do? What's their role? What's the reasoning behind this? What's the objective justification for giving this individual a covenant that they can't work for a certain business in a certain role for a certain period of time? So what you may have is restrictions that do have that, you can't work in the same or similar role within X business or X sector for a period of time. You may also have other restrictions that think about, okay, well, we're quite happy for you to go and work for somebody, but you can't take our employees. So it may be that you have a key employee restriction. So for a period of time, you won't take anybody perhaps in a leadership role, marketing role, business development role, whatever that might be within that window. You may also have clauses there that talk about clients and prospective clients. You may name those clients as well. That's a really useful way of doing it. So we're absolutely clear from the face of it, look, we don't expect you to leave us, but if you do, then the expectation is that you will not work in a similar role to what you do now in competition with us for ABC businesses. You may also have clauses in there with regards to suppliers as well, so not disrupting that supply chain, and that they're sort of the core terms that you must have, or you may want to think about having. But really, just that point at the end of the slide there, it's to prevent unfair competition. It's to prevent somebody from using what they've learned from you because they have worked for you, then to be used against you unfairly. Now, there is something that people will say, well, I've learned stuff just because I've been doing my job for a long time, and I haven't necessarily got that because I've worked for company A. I've just learned that because I've been doing the job for 5 years, 10 years. So that would be called your know-how, the way you've learned how to do things, and you would have learned how to do that regardless of who you work for. So again, you can't stop people from, knowing how to put a presentation together, or how to, run a webinar, or how to, draft a contract. Those are things that are learned because of what they do, not necessarily because they work for you. So again, there's that balance, that reality in terms of, that unfair competition. Even though you have a restrictive covenant within your contract of employment, does not guarantee that that clause will be enforceable. And I think that's really important to stress. We don't give any guarantees in terms of what we've drafted, because it's up to a judge and a court at the end of the day to decide if they think that that's fair and reasonable. Also, restrictive covenants are not suitable for all employees. They are really only suitable for those individuals that have those sort of, senior positions, those client-facing roles that would pose a risk to you if they were to leave you. So, if you're going to have those blanket clauses in everyone's contract of employment from, junior to senior, you just dilute the value, because you're saying to the court, well, we don't really particularly we haven't really thought about these clauses. We've just stuck them in everyone's contract. So we're not saying that, one person is, more of a risk than somebody else. So again, no blanket clauses. I would like to see somewhere written down the rationale for why that role has the restriction, and why you've decided that it's for 3 months or 6 months. Why? So I would like to see that written down. Also, the restrictive covenant has to be reasonable at the point it is signed. So we're not crystal ball gazing here. We're not saying, okay, well, we've taken somebody on as, a junior, but, we hope that they're going to stay with us and they're going to have more client contact. So actually, say they're only here for 5 years or what have you, that actually let's put some restrictions in their contract now because, we might need them in the future. No. They have to be reasonable at the point that they are signed. So we can't sort of think, well, we might need them in the future. which is why I'm saying, you know, go back, review your contracts where you've got your pay reviews or where you've got your, where people are being promoted. What do we need to do? Do we need to think about notice? Do we need to sort of flex our confidentiality or our IP clauses? And do we need to think about now maybe including some restrictive covenants or enhancing those restrictive covenants? Garden leave clauses and restrictive covenants also work hand in hand. So, for example, it would be unreasonable to ask an individual to sit on garden leave for 6 months and then have a restrictive covenant that then lasts for 6 months. So effectively, you are locking somebody out of the market for 12 months. What you find is that any period of time spent on garden leave knocks off any period of time that somebody then spends on a restrictive covenant. So if you've got somebody on a 3-month notice and a 6-month restriction, if you put them on garden leave for 3 months, then you've got another 3 months when somebody leaves you. So you need to think about how that notice, garden leave, and also the restriction works. It is far easier to enforce a garden leave provision than it is to enforce a restrictive covenant. So always go back and think, actually, I know I've got to pay this individual for the length of their notice period, but actually it might be cheaper, both from a commercial perspective and a legal perspective, to do that rather than let the person go out into the wide world and then try and enforce these restrictions through the courts. Because restrictions, when you seek to enforce them, you're doing it through the courts, through injunctions. It's quick. And a lot of money is spent very, very quickly, particularly when you think about undertakings and things like that. So yes, they are useful, but I think we need to think very carefully about why we want restrictions, what type of restrictions we want, and who we want to give the restrictions to. And as I've said, don't be afraid to go back and revisit the restrictions. So spend some time thinking about the contract of employment. And I think really, you know, when I run training sessions on, you know, for managers and for leaders, we spend a lot of time talking about the recruitment process. And this is really linked to that. You know, before we kind of rush off and write job descriptions and get very, very excited about interview questions, we need to think about where are we pitching this job in terms of contract, what protections we might need, what's the individual going to be doing. Let's sort of scope that out. So again, really think about your contract of employment. It's not just a document that you just have to sign. It's an HR hassle. It really is an important and strategic document that you can use as part of your, you know, your HR toolkit. Always follow the contract of employment. Whenever I speak to a client about, so say, for example, somebody wishes to exit an individual from the business, my first question will always be, I need to see their contract. If you don't follow the contract, so for example, you fail to give correct notice or you breach the contract, you know, trust and confidence, that implied term, then you can't then seek to enforce it. So all of those restrictions that you have, they fall away. So we must always, always follow the contract of employment, which is why it's so important to make sure that that employment contract is adequate and is fit for the job that the individual is doing. So that's particularly important where you've got those post-termination restrictions. You know, if you're not going to follow the contract, then you can't expect to enforce those terms. I spoke at the beginning about those 4 elements of contract formation. And one of those was consideration. So when you give someone an employment contract at the start of the employment, that consideration is them joining you and you paying them, and that promise of you know, employment with you. When we start thinking about changing contracts of employment where people are promoted, we need to, and we want to include those post-termination restrictions, for example. We want to increase the notice period. We need to think about what's the consideration going to be. Is it the fact that you've got your promotion, or actually do we need to be attaching some form of value to the clauses that we are now asking you to sign up to? So again, always take advice on that consideration point, because again, if you're not giving the employee any value for those post-termination restrictions, those restrictions on them being able to leave you and find another job, then again, we can't then seek to enforce them. So always take advice when you are thinking about giving people post-termination restrictions or other sort of, longer business protection terms whilst they're still in employment with you. And as I've said, we need to get the employment contract right and those terms right at the point that we sign it. As I've said, we're not crystal ball gazing here. And also, we can't impose a fundamental contractual change on an individual. To do so would be a breach of contract, allowing that individual to resign, and if they've got 2 years service, claim constructive unfair dismissal. So how can we help? What are we doing? Well, when was the last time you reviewed your contract of employment? Things change. Things have changed. Certainly we saw some changes back in April 2020 and 21 around contracts of employment and what that sort of section 1 needs to achieve. But also, is your contract and your policies as well, your handbook, your policies, can you really say that they reflect your culture and who you are as an organization? Are they written in sort of, quite formal language? Are they written in plain English? If you don't understand something, then how is your manager going to be able to understand how they follow a sickness absence procedure, or when does, what's the notice procedure? What options do you have? Again, assisting with those implementations. So what are we doing? Are we really sort of covering off that consideration point? And what is reasonable as well, helping clients draft those post-termination restrictions and helping them with that implementation, and also helping them with rollouts as well, because there are certain rules around if you are thinking of changing contracts of employment, particularly when you're thinking of changing contracts across the board. Again, we need to be very careful and very mindful about all the other legal implications involved in that, particularly around collective consultation, because again, when we're thinking about changing terms and conditions, that can also click into collective consultation obligations as well. So again, always take advice on that point. I have had a couple of questions through. I haven't had a chance to read them. So in terms of the session, it is recorded, so you will get a recording of the session, and so the slides will be in that. Can we use the offer letter? You can use the offer letter, which forms part of the kind of the overall sort of contractual package. I would just be very, very clear in terms of what that offer letter says, and that intention there in terms of what you're including within that offer letter, and also making sure that if you are having an offer letter and a written statement of terms, that they actually say the same thing. Because from experience, I've seen offer letters which literally have no relation to the contract that is then later signed. So again, it's about having that, the HR, the devil is in the detail. So making sure that you've got that synergy between an offer letter and any written statement, and be clear that the offer letter is part of the contractual statement and the contractual package. Again, does the notice period have to be the same for both parties? No, it doesn't. But remembering again that you may want to have that synergy between employee and employer. It might be easier to remember when you've got equal notice. But again, notice has to be reasonable if you're not going to be following that. And someone said, is there a legal limit to how long someone can be asked to be on garden leave? Garden leave is really for the notice period. It's for those times. Suspension may be different, particularly in the sort of an investigation type scenario, but garden leave is really, it's linked to that notice period. So if someone's on a 3-month notice period, garden leave for 3 months, or you might say to somebody, well, we want you to work for maybe half of that and then have garden leave for the second half. So again, you don't have to put somebody on garden leave for the whole period, but it does give you that fantastic flexibility and perhaps that ease with regards to where you want to, have that, let's use garden leave and a longer notice period, rather than relying on having to, go to the court, seek an injunction, try and enforce a restrictive covenant as well. And some questions there about hybrid working. I think a lot of organisations are going through the same issue with hybrid working. my preference would always be to have an office as the principal place of work. I say that because if you need people to attend a meeting, if you need people to attend a training event, you need that ability to be able to say, we can ask you to come to the office. And also things change as well. We don't know where we might be in 6 months, 12 months time in terms of where we want our people to work. So I think it's always worth, preserving within the contract that ability to have that principal place of work. And then you might want to refer to a hybrid working policy, that separate policy. But again, it's always down to job, need, and expectation, isn't it? And I think, as I've said, where we are now may not be where we might want to be in 6 months or 12 months time. So again, allow yourself that ability to be able to flex. Places of work are quite tricky, because there's always that, how do we change a place of work? When is changing a place of work a simple change? You've got that reasonableness. But when does a change of place of work become unreasonable? And when does a change in the place of work actually potentially, if we're closing an office site, when does that look to be a redundancy? So again, always take advice on, changing places of work. But I would still maintain a place of work, a principal place of work within that, within your contract of employment. And again, someone said, there are expenses and issues around that as well. So thank you very much for joining the session. As I said, you will receive the recording link to our YouTube channel, and also have a look on the YouTube channel, because you'll be able to see our previous webinars as well. So that would be interesting to have that, see what we've done. So our April updates, our legislation updates, and also talking about other issues. So for example, last month we were talking about communication skills as well. So thank you very much. We will be back in September, where we will be talking about status, and we will be talking about IR35. So something to look forward to as we move forward into the summer. Have a wonderful summer, everybody, and I look forward to seeing you all in the autumn. Many thanks. Bye-bye.